Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. And I am living up to the name 24/7. This is crazy. All right, y'all. I don't know. I guess before the holidays, folks want to get all their crap filed before next week. So, this is in regards to TD Jakes versus Duane Youngblood. If you have not watched yesterday's video, TD Jakes' lawyer filed a motion to expedite discovery, and I pretty much break it down yesterday so you guys have a general understanding of the process. In reading the motion, TD Jakes has asked the court to issue subpoenas to Larry Reed and Larry Reed's company so that they are able to identify the other John Does in the case. Reed was named in the motion, as well as Attorney Blackburn. And if y'all don't know who Attorney Blackburn is, Attorney Blackburn is representing a couple of individuals in as plaintiffs in the Diddy cases. I know that he's representing a few individuals in DJ Academics cases. So he's out there, but his he has been questionable when it comes to his duty as an attorney. Let's put it that way. So, as I explained last night, they served Duane Youngblood on December 4th, and they filed a affidavit of service saying that they did went ahead and served him, and it stated that he has until December 26th to actually respond to the lawsuit. So that is where we are here today. So he has actually responded to TD Jake's lawsuit. Now, as of right now, he does not have an attorney. We were under the impression that possibly attorney Tyrone Blackburn was going to be his attorney because he's the one who sent, I believe, the extortion letter to TD Jakes. And I don't know what happened after that, but Blackburn did let Jakes and his attorney know that he was not representing Youngblood. So it's just like, okay, what's your correlation in this? So here is Youngblood's statement. It's about 6 pages. I've seen some pictures in here, so I don't know exactly what we're gonna see. I know it's not bad because I just skimmed through them, but we'll go through this. So he is writing as a pro se defendant in the above caption matter to respectfully request a 30-day extension to okay, so well, he responds, he still responded, but he's requesting a 30-day extension to respond to the complaint and to file an anti-slap motion. And I am going to not break everything. I'm going to explain what the anti-slap motion is in just a second once I finish with the letter. I am currently in the process of attempting to retain local counsel. However, as I am only employed part-time, securing legal representation has proven to be financially challenging. I believe an extension would provide me with the necessary time to obtain appropriate representation and to prepare a thorough response and anti-slap motion to dismiss. Your Honor, I have unwavering confidence that the court will discern the lack of merit in the plaintiff's claims, and I firmly believe constitute a violation of my First Amendment rights. The United States Constitution guarantees that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. This fundamental right underpins my ability to share my life experiences, truthful and supported by evidence, as protected speech. In support of my defense, I intended to present seven sworn and notarized affidavits, which corroborates the facts I've shared for over 3 decades regarding the trauma I endured as a teenager as a result of the plaintiffs and other actions. These affidavits will be accompanied by photographic evidence from the period in question, including images taken during the month I met Mr. Jakes and during events at the church where he preached. Hey Tyron, how you doing? Thank you for coming back. I was just doing this, reading this, and hopping right back off. All right. So, additionally, I have provided documentation of complaints I made to Senior Bishop of Higher Ground Always Abounding Assemblies, HG AAA, of which Mr. Jakes is Vice Bishop. These complaints include a conversation facilitated by Senior Bishop Sherman Watkins between myself and Mr. Jakes during a visit to my church between 1992 and 1993. At the meeting, I directly confronted Mr. Jakes regarding his actions, and he made a revealing admission that supports my claims. It is important to emphasize that I have expressed concern about these events spanning multiple decades in the late 1980s, 1990s, and early 2000s. Despite my consistent and public recounting of these incidents, Mr. Jakes did not see fit to file a defamation lawsuit against me during any of those years. This inaction suggests that Mr. Jake himself recognized the validity of my statements or deemed them unworthy of legal challenge at the time. Furthermore, it is telling that Mr. Jakes actively participated in my 2004 ordination as bishop in HG AAA, serving as one of the consecrators despite his full awareness of my public statements about his actions. So I'm assuming he's saying that he's been talking about this for years and Bishop didn't do anything until now. Mm. I'm gonna keep my opinions to myself. These facts highlight the baseless nature of the current lawsuit and further affirm my assertion of truth. The legal principle at stake in this case is grounded in the precedent established by New York Times Company versus Sullivan, which provides robust protection for individuals expressing opinions or recounting personal experiences, even if they are controversial, providing they are truthful or expressed without actual malice. Furthermore, in Hustler Magazine, Inc. versus Falwell, it stated that the Supreme Court reaffirmed that speech about public figures related to matters of public concern enjoys heightened protection under the First Amendment. The United States Supreme Court's decision emphasized the paramount importance of safeguarding freedom of expression, particularly in cases involving significant public interest or personal narratives. I respectfully request the opportunity to include photographic evidence with my forthcoming filings to support my assertions. This includes, so pretty much what he is saying is that he never defamed TD Jakes because it was his personal experiences, and he has the right to discuss his personal experience because of the First Amendment, which is the freedom of speech. That is what he's saying. Oh, look at this. This is a photograph of him when he was a teenager, and that was taken during the month that he met Mr. Jakes. All right. A photograph of myself performing at the church where Mr. Jakes was preaching during the relevant time. Okay. Photographs documenting my 2004 ordination ceremony with Mr. Jakes officiating. Ooh, that's him right there. That's Bishop. I contend that this lawsuit represents an attempt to silence me and suppress my First Amendment rights. It is neither unlawful nor defamatory to truthfully share one's life experiences, as I did during my interviews on October 28th and November 3rd, 2024. Plaintiff Jakes has used his position to harass and target me throughout the years, and as recently as November 3rd, 2024, had his son Jermaine Jakes reach out to me and threaten me on social media. This threat is what led me to seek out legal counsel, as I was and am in fear of my life and safety. Upon information and belief, Bishop Jakes and his family have a reputation of having individuals who challenge them or expose their dirty dealings disappear throughout the years. Oh, so now you're trying, oh my gosh. So this is Jermaine. You might be dangerous territory, Derain. Be careful. Mm. In conclusion, I respectfully request that the court grant me a 30-day extension to secure legal representation and to prepare and file my anti-SLAPP motion to dismiss. Let's see. And let's see what else he said. I appreciate the court's understanding and consideration of my circumstances. All right. So with this being said, he has responded and he has asked the court to grant him an extension so that way he can find counsel. Pretty much what he's saying is that this lawsuit is pointless and I am protected by the First Amendment, freedom of speech, because everything that I have been saying is my life experiences. And so he's wanting to also file his anti-slap motion, and that's usually like a procedural tool that allows defendants to actually dismiss a case because the complaint is meritless. Here's my thing with this. Hello, God blesses 23. How you doing? Here's my thing. You how can I even say this? You sent a letter to him demanding $6 million, and if he did not pay, you are going to continue to, I don't even think you said tell your story. You pretty much said I'm going to continue talking. So if y'all can kind of see that's pretty much extortion. Like, you blackmailing. If you don't pay me, then I'm gonna do this. So you are using what you say to defame him and harm him unless he pays. Now make that make sense. Please make that make sense. But that is all that I have. I just wanted to give you guys Duane Youngblood's response. Once again, I didn't see any updates as far as the TG Jake's motion to expedite discovery. If it is granted, then those two subpoenas, one to Larry Reed and to Larry Reed Company LLC, something like that, will be subpoenaed, and they will request all of the records that they need in order to identify John Doe's, what, 3 through 10, because they already named well, I don't know, it's probably John Doe's 1 through 10 plus attorney Blackburn plus Larry Reed. So this is going to be a very interesting case. On top of that, the judge will also determine whether or not to grant Duane Youngblood time to that 30-day extension, in which I don't see why he wouldn't, because if anybody's stating that, they're having a hard time to find legal counsel, they are, considerate of that and will allow him 30 days to do just that. So this is very interesting, and this is definitely something I'm going to keep on the docket, because I have to see what in the world is going to happen on this. Because if y'all haven't watched the first video that I did, Duane Youngblood has been out here extorting pastors for decades. On top of that, his record ain't looking good. Like, you have been caught and you have been tried and charged and tried for messing with minors, male minors. That is crazy, right? Yeah, so definitely tune in. I started making playlists, so if you want to just focus on one, um I don't want to call it a current event, but one subject, then more than likely that will be something y'all can go over there and choose. But other than that, tell me what y'all think about this TD Jakes and Duane Youngblood. If you don't know, go watch the videos and come back and comment, and then you'll understand why it's happening. But Dwayne is a character. Dwayne is a character, and I know Mr. Larry Reed. I haven't went over to his YouTube page yet, but I'm wanting to know what he thinks about being subpoenaed because he can't get rid of no evidence. He has to turn everything that he has over to Bishop T.D. Jakes and his attorney if the court allows them to expedite discovery. But tell me what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and have a good night. Bye.